Today, we're going to dive into a really fascinating and kind of tricky corner of property law. It's a place where the strict rules of law sometimes have to bend a little for the sake of fairness. It's a story all about promises, property, and what happens when one of those promises gets broken. Welcome to the world of proprietary estoppel. You know how it is. We're all told that when it comes to something as serious as a house or a piece of land, every deal has to be official, written down, signed, sealed, the whole 9 yards. But what if it isn't? Imagine someone promises you a share in their home. You believe them. You change your entire life based on that promise. And then they just turn around and say, never mind. It actually happens way more than you'd think, especially in families or close relationships where trust takes the place of a formal contract. And that's the exact messy situation that proprietary estoppel tries to fix. So to really get a handle on the solution, we first have to understand the problem. The best way to think about property law is like a fortress. It's built on a solid foundation of very strict, very formal rules, and they exist for some very, very good reasons. So why all the red tape? Why does the law insist on all this paperwork? Well, this breaks it down perfectly. First, there's the evidentiary function. A signed deed is concrete proof. You can't really argue with it. Second, it's cautionary. The whole formal process forces you to pause and think, wait, am I absolutely sure about this huge decision? And third, channeling. It pushes everyone down the same correct legal pathway. It's all about making things certain and stopping fraud before it starts. But here's the massive catch. As the legal scholar Burke pointed out, formality breeds hard cases. These super rigid rules, which are designed to create justice, can sometimes become a trap. They can backfire, especially for vulnerable people who might trust a loved one and not think to get a lawyer. The very system that's supposed to be fair can end up creating a deeply unfair situation. So if property law is this big, imposing fortress, what happens when someone is unfairly locked outside the gates? Well, it turns out the law has a kind of secret door, an escape hatch. It's a doctrine called proprietary estoppel. Let's see how it works. In a nutshell, proprietary estoppel is the law's fairness safety net. It's this powerful tool that courts can pull out when someone tries to go back on a promise about property, and it would just be fundamentally wrong to let them get away with it. That's what lawyers mean when they use the word unconscionable. It's about stopping an outcome that would shock the conscience of the court. And what's really cool is how it works. You can think of it as both a shield and a sword. On one hand, it can be a shield. You can use it to defend yourself if a landowner tries to evict you after you've relied on their promise. But on the other hand, it can also be a sword, allowing you to go on the attack and make a brand new claim for a right in that property. It's got both defensive and offensive power. So how do you unlock this secret door? Well, it's not easy. It's definitely not a free-for-all. A person making a claim has to prove 4 very specific things to the court. Let's think of them as the 4 keys you need to turn to open the lock. The very first key is an assurance. This is the promise, the heart of the matter. It could be a single clear statement, or it could be a general impression that's built up over years through little comments and actions. The main thing is it has to be clear enough within the context of the relationship for the other person to have reasonably believed it was a real promise. The second key is reliance. You have to show that you acted differently because you were counting on that promise. Now, what's interesting here is that the promise doesn't have to be the only reason you did what you did, but it does have to be a big one. And get this, if you can prove you suffered some kind of loss, the court will often just assume you were relying on the promise. The tables can actually turn. Third up is detriment. This is all about what you've lost or sacrificed, and the courts define this really, really broadly. We're not just talking about cold, hard cash. It could be about giving up your career, working on a farm for years for little or no pay, or any other massive life-altering choice you made because you trusted that promise was real. And the final key, and honestly this is the most important one, is unconscientiality. This is the absolute core of the whole doctrine. The judge basically steps back, looks at the entire situation, and asks a simple question. Would it be morally outrageous, just fundamentally unfair, for the property owner to break their promise now, especially after everything the other person has been through? Okay, that's enough of the theory. Let's put this into practice with a case study and see how it all works in a real-world scenario. Let's talk about Jack and Diane. Their story is going to put all 4 of these keys to the test. So here's the play-by-play. In 2014, Diane makes a huge leap of faith. She sells her own home to move in with Jack. Just a year later, she's digging into our own savings, putting £40,000 into renovating his house. By 2016, she's not just putting in money, she's using her professional skills as an architect to design and build a guest house on his property. You can really see her level of investment and commitment just getting deeper and deeper over time. Okay, so let's test that first key, assurance. Early in the relationship, Jack says, "You can think of this as being your home too." Now, that sounds lovely and reassuring, doesn't it? But legally, it's pretty weak. A court is likely to see this as the kind of vague, romantic thing people say in a relationship, not a concrete promise to give away a legal interest in a property. It's just too fuzzy. Next, let's look at detriment. Diane spends 40 grand of her own money on renovations. That's a clear financial loss, for sure. But here's the tough question a court would ask. Was she spending that money because she was relying on his vague promise? Or was she just, making the house she was living in a nicer place to be? Proving that direct link can be incredibly hard. But then, in 2016, the situation changes. While Diane is pouring her heart and soul into designing and building this guest house, Jack says this to her, repeatedly: "You are amazing. This really is your guest house." Now, this sounds much more like a specific assurance, right? It's not about the whole house anymore. It's zeroed in on the guest house that she is literally creating. And now look at her detriment connected specifically to the guest house. It's massive. She's contributing her professional architectural skills, which are valuable. She puts in another £50,000 in cash. And she's spending her time providing hands-on supervision for the whole project. This is a huge, undeniable contribution, and it's tied directly to Jack's much clearer words. This really is your guest house. So what's the likely verdict here? Well, the legal analysis is pretty tough. Even with that stronger statement about the guest house, the earlier promises about the main house were just too vague. A court would almost certainly say Jack has to pay Diane back for her financial contributions. But to give her an actual ownership stake and interest in the property itself, that's very, very unlikely. It's a harsh result, especially after everything she put into it. And this case really just perfectly illustrates the central conflict, the big tug of war that's right at the heart of proprietary estoppel. It's this constant, difficult balancing act between trying to achieve fairness in one specific case and the need to maintain certainty for everyone else. And this is where things get really unpredictable. A judge has this huge menu of options to choose from, as you can see here. Their goal is to find the minimum equity to do justice. That could mean anything. They could grant full ownership, give someone the right to live there for life, just order cash compensation, or even decide to award nothing at all. This flexibility is what allows for fairness, but boy, does it make the outcome hard to guess. So, as you can probably imagine, all this flexibility leads to a massive debate. Critics argue that proprietary estoppel is actually a dangerous tool. They say every time a court uses it to get around the formal rules, it chips away at the certainty that property law is supposed to be built on. The big fear is that it's becoming this messy, unpredictable fix-all that might be creating even more problems than it solves. Which leaves us with this big question. Is proprietary estoppel a vital safety net for justice, or is it a dangerous crack in the very foundation of the law? And this really matters because these aren't just abstract legal puzzles. They involve real people, families, partners, people who trusted each other enough not to get things in writing. It forces us all to ask, when relationships fall apart, what does the law really owe us? Certainty for all, or a shot at fairness for the one?